So hello, thank you for joining us today for our webinar on what to expect from the DC non-compete ban. My name is Margeaux Thomas. I'm an attorney with the Thomas Law Office. I do exclusively business litigation, resolving contract disputes with clients and customers and vendors in the DC, Maryland, Virginia area. We also have Shavon Smith joining us today.
Hi, thank you. My name is Shavon Smith with the SJS Law Firm, and I represent businesses and business owners in DC and Maryland in employment matters, contract matters, and really being their legal eyes and ears.
All right. You go to the next slide.
Next slide.
Okay, so I think to frame the issue of the new DC non-compete ban, we need to talk about just a little bit of the history of non-compete agreements. And here are a few of the notes and, my personal viewpoints on, how non-competes have evolved. There has been a substantial amount of litigation involving non-compete agreements. A lot of situations come up when employees leave a business and they set up shop across the street. They may be taking, information with them, training with them, people with them, client lists, things like that, trademark, any type of, trade secrets, things like that. And we get in situations where if that employee or contractor signed a non-compete agreement, there may be litigation over the enforceability of that agreement. In general, I'd say that non-competes are usually disfavored by the court because they are considered a restraint on trade. To enforce a non-compete is basically going to mean that a person that is employed by someone else or has started their own business is not going to be able to continue to operate in that way. So it is going to restrain their ability to, make income, run their business, and profit profit in society. So there's always this balancing act that the courts will do in non-compete cases, weighing the right of an individual to work in our free enterprise society versus an employer's ability to profit in their business and to restrain unfair competition. So courts have always leaned towards finding these types of clauses unenforceable when they're overly broad, unduly harsh, and oppressive. But DC has taken the additional step and taken one of the more aggressive approaches that we've only seen in a few states in the US and outright ban non-compete agreements. So we're going to talk about that a little bit more today.
So as it relates specifically to the DC ban, all of the reasons that Margeaux just talked about in terms of why they're disfavored are the exact reasons why DC enacted this law. If you read the Attorney General's website, they have a press release on some of the nuts and bolts of the law. And that's exactly their statement on it, that they have a belief that it, harms workers, it harms the labor market, but also data showing that non-competes depress or reduce wages across wage types. So whether they're low income earners or high income earners. So this particular law was signed into act in January 2011 by the mayor, and DC then joined a few other states, California, North Dakota, and Oklahoma, that have broad bans. Other states do have bans, even the states surrounding DC, but not as broad as DC's. There's been a little confusion as to when the act takes place. It became effective March 16th. But it actually becomes applicable in February 2001, and that has to do with DC and the way laws are enacted because it's not a state and funding and everything like that. But that is when it becomes effective, and that is when, if you are an employer, you could face penalties for not implementing this properly. So it's good to get on the right page now. Next slide, please. So again, the ban is pretty broad in terms of the definition of employer and employee, and I think we'll talk a little bit about that in the next slide, but essentially it is anyone who employs people in DC, and an employee is anyone who works in the district. And there's not an income requirement. So it could be a high wage earner or a low wage earner. But there are exclusions, for instance, for certain types of volunteers, for religious organizations, for casual babysitters. And then there is a caveat for medical specialists. It does have to be a licensed physician, and they have to be making more than 250 a year. So very limited exemptions from the law. So most employers in DC, with the exception of the federal government and DC government, will be required to follow this law. Next slide, please. So as mentioned, the law prohibits pretty much any sort of non-compete ban, but that's also language or policies you have that prevent an employee from holding jobs simultaneously, but also any sort of laws you have about an employee operating their own business. So phrases like, full-time and attention to a particular job could possibly be problematic with this particular law. Next slide, please. So notice. So there are notice requirements with this law. The language that's written here, and I'll just read it: no employer operating in the District of Columbia may request or require any employee working in the District of Columbia to agree to a non-compete policy or agreement in accordance with the Ban on Non-Compete Agreements Amendment Act of 2020. That language is statutory. So the notice that you do give to employees, it has to be that exactly. Perhaps you could have some other wording around it, but you have to have the magic words there. So for current employees, you have to give them this notice within 90 days of when the law becomes applicable. So that would be probably by the end of this year. So it's something you want to start planning for now in terms of how you will provide this notice. When you have new hires, you have to provide that within 7 days. So you definitely want to make a plan. So however you onboard new employees, you want that to be part of what you provide to them in the packet as well. And then also, if an employee requests notice about the act, you have to also provide that as well. I don't believe that DC has an actual poster for it like they do for other laws, leave laws, workers' compensation, but it also may be something that you want to post along with everything else, wherever you have your employee posters, just to make sure you are completely covered. Next slide, please. So as mentioned, it subjects you to certain liabilities. So there are definitely penalties if you do not adhere to this. So employees have a private right of action, meaning that you can go to court in DC Superior Court and sue your employer, or you can file an administrative action as well, perhaps with the DC Human Rights Commission or an agency designated by the mayor. Fines are going to include, so if you request that an employee signs one, again, that is, in prohibition of the law, that fine is not less than $500, but not more than $1,000 per violation. If you attempt to enforce one, so for instance, if you send some employee an angry letter telling them about this non-compete you have, so that would be an attempt to enforce a non-compete. That violation is not less than $1,500 per violation. And if you retaliate against an employee, so there's also an anti-retaliation part of the law as well, so that if a employee asks a question about it, isn't this right? Why do you have this policy? You're not supposed to do this. And you retaliate in some way, perhaps you cut their hours, perhaps you fire them, perhaps you give them a less desirable work schedule. All those things could be seen as retaliation. Those violations are between $1,000 and $2,500 per violation. And if you are a repeat offender, of course, all of those things become heightened, and a court could increase the penalties as well. And there's also employee fee, attorney's fees. So if an employee were to litigate this and they were victorious, and given how broad it is, and I'm sure Margeaux will talk about it, I don't see how they couldn't be. There's also a provision for attorney's fees as well. Next slide, please. So again, as I mentioned, DC joins California and South Dakota in kind of the broad non-compete. Maryland and Virginia also have them, but they're very narrow and really more aimed at the wage that a person makes. And I think that goes to the belief that the lower wage, maybe the less bargaining power you have or negotiating power you have in your job. But in DC's position, they think that lack of bargaining power probably is across the board, which is why they haven't acted it. Next slide, please.
So there's a few potential litigation issues that we could see coming down the pike, depending on how the mayor handles some language that's currently in the act and some language that isn't, that is, issues that are just silent. And the first issue is non-solicitation. The act is silent on whether this non-compete ban applies to non-solicitation. And non-solicitation is basically when you contact a company's customers or clients, vendors, and try to get them to go to, let's say, your new employment, your new job, or a company that you just set up. So you're trying to take their people to your new place, or their employees for that matter. So if you think of it from the restriction on trade viewpoint, it's probably, non-solicitation is probably underneath a non-compete. It's probably similar to the same restriction on trade that DC is trying to prohibit. So it's likely that non-competes could be included in that, and that would also be a violation of the act, but right now we don't know because the act does not mention non-solicitations specifically. So we'll see if the mayor will provide additional guidance on this issue before the act becomes applicable later this year. And if not, I think that's likely one of the issues that's going to be ripe for some litigation, because non-solicitation is very important, is an important consideration when business owners are at issue. So if you could go to the next slide, thank you. The second potential litigation issue concerns how employers and employees are bound, which ones are bound. Specifically because in the midst of COVID, there's so much teleworking, lots of employees are working from home, lots of employees that were working in certain areas or jurisdictions have moved because they don't have to report to the office anymore. So employers that used to have a base of employees that were local, that might not be the case now, especially in the upcoming years when people aren't tied to a desk in a specific location as much as they were before. We've seen so many businesses convert to being able to do a lot of things remotely, and that's definitely going to affect how this act is applied, because it defines employer as basically a business that's operating in DC, which is very broad, and it applies it defines employee as an individual who performs work in the district on behalf of an employer. So it begs the question that if you are an employee that works from home, that lives in DC, but works for a company that's somewhere else, if let's say the company's in Virginia, is that company, just because they have an employee in DC doing work, is that employer operating in DC? And is that employee, just because they work remotely and they live in DC, performing work in the district on behalf of the employer? So I think that more guidance we'll need more guidance on that issue about specifically what employers and employees this act is targeting, and especially with the increased remote work environment. Can you go to the next slide? One important carve out of the act is that it doesn't apply in the context of a sale of a business when the seller is agreeing not to compete with the buyer's business. And that is routinely a clause in asset purchase agreements. You don't want the person who is selling their business to then compete with the business that you're buying, for example. So normally there is some provision in that asset purchase agreement that says, you can't shut up shop doing the exact same thing within a certain radius for a certain amount of time and compete with the business that you just sold. So this act does not bar non-competes in that situation. And that means that there will likely still be litigation over whether those clauses are reasonable. They can't be overly broad just with non-competes before this DC ban. Of course, we're always looking at non-competes and trying to determine whether they were narrowly tailored, whether they were overly broad, whether they were prohibiting the exact same type of activities. So all of those balancing and weighing that the court was doing, they'll still be doing that in the context of business sales if there's a non-compete and somebody alleges that the other side who just sold their business is violating that clause. You could go to the next slide. Another litigation issue is the Act carves out client lists, customer lists, sensitive information, trade secrets. Those things are still fair game. So you can't, you can still end up in litigation when you're an employee and you take some potentially sensitive information from your employer and use that to your benefit. So it doesn't extend to these type of, it doesn't extend to, like I said, the client list, customer list, sensitive information, proprietary information. That kind of plays into the non-solicitation thing. I mean, are you soliciting? That's not in the Act, but then you can't per se take a client list with you. So the interplay between that will certainly be something that you may see in litigation and some case law in the future if there's no guidance given by the mayor now and when this Act becomes applicable later. You could go to the next slide. Okay, so just in general, and Shavon, feel free to jump in. I think the takeaways here are really that there's going to be a change in the law. It's probably going to take effect later this year. You need to be cognizant of that if you're a business owner operating in DC, especially if you have a brick and mortar business in DC. You're definitely going to be covered by this, and you need to start thinking about notice requirements. If you have form agreements that you use for every employee that you hire and it has standard language, now is the time to start looking at those agreements and making sure that they're in compliance with the law.
Yeah, I would say definitely, and like I mentioned earlier, agreements like policies that talk about full time and attention, but also conflict of interest policies that talk about doing things for other people, being a conflict of interest that could potentially fall under this ban as well. And I think another thing to think about, like if you are using independent contractors and you have non-competes in those, but they're not really independent contractors, you're definitely open to liability under this Act as well. So you also probably want to be assessing, doing just an audit of contractors to make sure that they are properly classified as contractors and perhaps they shouldn't be employees. Because I could imagine a situation where you hire contractors, you have non-competes in those contracts, but they're really employees. So I think you're still bound by this law as well.
Well, thank you, Shavon.
Thank you.
Joining me today. It's a great discussion about, the new changes in the DC law. Here is my contact information if anybody has any follow-up questions. I have been involved in almost 15 years of doing business litigation, so I've handled quite a few non-compete issues and have a few going on right now. So if you have any questions about any kind of non-compete issues or DC's new law, please do not hesitate to reach out. My email, phone number, website is all in the slides.
Yeah, absolutely. And if you have a question just about formulating your contracts and how to revise policies, definitely reach out to me as well. Do not call me if you have litigation. Please call Margeaux. But my email address is on the slide and my phone number as well, but happy to help you think through strategically your entity and implementing this law as well.
Thank you. Thank you all for joining us today.
Thank you.